Welcome to today's webinar, brought to you by the Current Consulting Group and sponsored by Scott Insurance. I'm Greta Walsh of the Current Consulting Group, and today's presentation is titled, How to Get the Most Out of Drug Testing in the Age of Legal Marijuana. Today's presentation qualifies for one continuing education credit from SHRM, HRCI, and CCDAP for those who attend the presentation in its entirety. You will receive information following today's webinar on how to apply for that credit. And now it's my pleasure to turn it over to Sandy Redmond from Scott Insurance.
Good afternoon, everyone. This is Sandy with Scott Insurance in Knoxville, Tennessee. We want to thank all of our clients and prospects for joining this webinar today. You ask us lots of questions about substance abuse laws in many states, and we are thrilled to have Current Consulting on this webinar to talk to you about this today. Now I'll introduce your speakers for today. Bill Current is on the call. Bill Current has started Current Consulting Group over 25 years ago. He's been at the executive level of many drug testing organizations, and he's written nearly a dozen books about substance abuse and drug testing. We also have Yvette Baker on the call. She is a senior attorney with Current Consulting Group with over 15 years experience, and she specializes in drug and alcohol testing laws. I'm thrilled to present them to you today.
Well, thank you very much, Sandy, and welcome everyone to today's presentation. As Sandy mentioned, I'm Bill Current, the founder of the Current Consulting Group. We've been around for, well, a lot of years. We were founded in 1998, and we specialize in, we don't provide any drug testing services. We're not a drug testing laboratory. We're not a TPA. We're not an MRO. What we do is provide the sort of essential compliance services that companies rely on in order to be able to conduct drug testing. So policy development, supervisor training, DER training, employee drug education programs. And we also have a very popular state law database called Current Compliance. And all of those compliance services are available to Scott Insurance customers at special rates. So all of our rates are published. And so if at any point you use any of our services, you'll be able to see that you're getting a rate that is specific to Scott Insurance customers. Let me just mention a couple of things real quick because it will support some of the information that we're going to share today. So for example, I mentioned our state law database, Current Compliance. This is a database of all laws at the state level that affect workplace drug testing. So it may not be a drug testing specific law. It could be a marijuana law. It could be a workers' compensation regulation, but if it has language in those laws or regulations that would affect drug testing in the workplace, then you'll find that information typically on in our database. So we have individual sections for each state in the database, and you can, click on a state on the map as you see on the left there, and it'll take you to that information for that state. We also have single issue charts. If you want to know, say, for example, the legal status of random testing in all 50 states, you can search it that way, or you can just search the database with keywords. And one of the things that I think is very useful is that when you go to a particular state, this is the home page for the West Virginia chart. You'll see that there's a heads up information for that state, and then any laws that may be applicable to workplace drug testing in that state, you'll find a link here. So there's over 150 line items of information in each state, depending on the type of law that it is. But you'll see under marijuana laws, for example, we have information about medical marijuana and recreational marijuana. And we're not telling you all of the information about distribution centers and manufacturing and growing laws and things of that nature. It only deals with how these laws affect workplace drug testing. Can you test for marijuana? Can you hold individuals responsible if they test positive, etc.? You'll find that information in there. And then on the right, as you see, there's citations for case law. So in West Virginia is a very interesting state because there's case law in the state of West Virginia that directly affects how or when employers can test. Reasonable suspicion and safety sensitive workers, etc., which is unique to West Virginia. The most common question we get asked when we write a drug testing policy, for example, we just signed on to update the drug testing policy for Home Depot. They're in all the states, and theirs is a little bit more complicated. But the most common question we get asked is, you know, which state applies to me? I'm in 50 states or I'm in 25 states. Which law do we comply with when we put our drug testing program together? And the answer is all of them. You have to comply with each state law that applies to you. And so if you're in California and Texas, you know that California is much more restrictive when it comes to drug testing. They've got some very restrictive case law in California, especially pertaining to random testing. But in Texas, it's very drug testing friendly. Well, as you put your program together, you don't want to necessarily base your entire multi-state program on the restrictive language in California, when in Georgia, Florida, Texas, etc., you have much more latitude. So we customize every policy that we write, and we add individual customized addendums to each policy. So one of the things that Sandy told us in preparation for today's webinar was some of the states that many of the Scott Insurance customers are located in. So I'm going to turn it over to my associate, Yvette Baker, and she's going to give you some examples from some of the states that probably many of you are either in or do business in. So let me turn it over to Yvette to take over from here.
Thanks, Bill. And thank you everyone for being on. I'm really thrilled to be here today to be speaking to you about this. Like my bio said, I'm a practicing attorney and I specialize in workplace drug testing laws, which are very detailed, and it really is a specialty that not even all employment attorneys know a lot about. So we were given a few states that many of you operate in, and just before we even get started, I'm just going to give you a little overview of some of these states so you can be thinking about this as we go through the presentation. Now this chart lays out Virginia, Tennessee, North Carolina, South Carolina, and California, and talks about what kind of drug testing laws apply in those states. We're going to talk about what a voluntary law is, what a mandatory law is a few slides from now, but just so that you have in your mind, Virginia, Tennessee, and South Carolina all have voluntary laws. North Carolina has a mandatory law. California has a whole constellation of laws. California has a lot of case law, and case law, I'm going to talk about it some more, but it's where the courts and the judges issue decisions on that subject that are going to apply to workplace drug testing. Now we can see the status of marijuana in Virginia and California. They both have legal, medical, and recreational cannabis laws. Now, WC discount and WC denial are about workers' compensation. So a WC discount is a workers' compensation insurance discount. Now, this applies to the voluntary states. If an employer chooses to comply with the voluntary law, they can receive a discount on their workers' compensation insurance premiums as an incentive to comply with that voluntary law. But just like the word voluntary implies, that's just the choice of every individual employer. They're not required to comply with the voluntary laws, and they're not required to receive the insurance discount. It's just an incentive to establish these drug testing policies. Now, workers' compensation denial means that if you comply with these drug testing laws, you can deny workers' compensation benefits to a person who tests positive. So as you can see, all of the states we have up here have a workers' compensation denial law, which says if you're testing in accordance with state law, then you can deny workers' compensation benefits after a positive drug test. So that's great to know. And we're going to talk about federal regulations coming up as well. So I'm going to explain all of this in some more detail because I know it's a lot to take in, but we're going to try to walk through it step by step. So this is the agenda we're going to go through today. We're going to start out talking about the differences between federal regulations and state drug testing laws. I'm sure many of you are regulated by the Department of Transportation or other federal agencies like that, but you're also going to have employees who are not regulated by the federal government and who are only regulated by state law. So we're going to talk about the differences there and what kind of laws apply. We're going to talk about how to make a single drug testing policy for an employer that's going to address multiple applicable laws, whether it's multiple laws within one state, mandatory laws, marijuana laws, workers' compensation laws, or whether it's a multi-state policy where you operate in multiple states and have to be compliant with the laws of many states in one policy. That's something that we can do. We're going to have a section talking a lot about marijuana laws and how to comply with the testing requirements of marijuana laws. And that is so important in this day and age, and something that an employer really needs to revisit on a regular basis because it's changing so rapidly. Then we're going to talk about the consequences of dropping marijuana testing completely. Is that a good idea? Is that a bad idea? You know, what factors do you need to weigh if you're considering that? And lastly, we're going to talk about oral fluid testing, lab-based, rapid results, comparing it to urine testing, hair testing, and a return on investment. So that's the agenda. We have a lot to go through, and I apologize if I talk too fast, but I really want to get you all the information that you want. And like Greta said, if you have any questions, we welcome questions. Just put them right into the question box. And we're going to try to get to as many as we can on air, and any we can't get to live, we're going to respond over email. So we're going to start out talking about federal regulations versus state drug testing laws. And as I mentioned in our very first chart, we have all kinds of different state drug testing laws. We have mandatory and voluntary laws. We have about 17 states, 4 cities, and 1 territory that have mandatory drug testing laws. And just like it sounds, these laws apply to any employer within that state who wants to conduct workplace drug testing. If it's a mandatory law and you're drug testing employees in that state, you have to comply with that law. Now, the voluntary laws offer an incentive for compliance, and there are about 16 states that have voluntary laws. Now, these laws, if an employer wants to test in a way that's not permitted in the voluntary law, they can make the decision, you know what, I'm going to test differently. I'm not going to follow that law. And the consequence of that is you don't receive the incentive or the benefit attached to that law. But it's perfectly legal to do drug testing outside of the voluntary law and choose not to receive that benefit. So those are great to know about. We have case law, and like I mentioned with California, case law is where a court or a judge makes a legal decision on the subject of drug testing, and that now their decision becomes law and has to be complied with. We see a lot of case law regarding issues of privacy and whether drug testing violates an employee's right to privacy. We see a lot of case law that has to do with marijuana and how to apply marijuana laws to workplace drug testing. And there's a lot of different issues that can come up in case law. We have workers and unemployment compensation laws that are going to apply to workplace drug testing. And these operate a little more like a voluntary law. If, as an employer, you want to deny someone workers' compensation or unemployment compensation benefits after a positive test, say someone tests positive, they're fired, and they apply for unemployment compensation, and you want to deny that request because of their positive drug test, you need to do testing that complies with the unemployment compensation law or the workers' compensation law. And if you choose to test in a different way that's not permitted by that law, it's all right. The only downside is you're not going to be able to deny workers or unemployment compensation benefits as a result of that drug test. We also have industry-specific laws that might apply to mining, public works, childcare, bus drivers, construction, that sort of thing. Those are mandatory to comply with within that industry. And then we have medical and recreational marijuana laws, which I'm going to talk about some more. Now, I kind of ran through this all before I actually got to my slides. I got ahead of myself. But like I said, mandatory versus voluntary, I discussed what that is. Employers can choose not to comply with voluntary laws, and that usually is a balancing test with the costs of doing testing the way you want it versus receiving the benefit. Case law is only binding in the state in which the case is decided. So we have a lot of case law in California that those decisions are not going to apply to your employees that are in Virginia or that are in Arizona. They're only going to apply to your employees that are in the state in which that case is decided. This is a really big reason why it's great to be connected with an organization like ours that drills down on drug testing, because to know what cases are in a given state can be really difficult if it's not something that you specialize in. Like I said, unemployment compensation and workers' compensation is only required if you want to deny those benefits. And this can vary a lot. Some states don't have, I would say even most states don't have specific requirements for testing to deny these benefits, but some do have very specific requirements. So you really do need to be educated on the laws in the state in which you operate. And industry-specific laws, compliance is required for within that specific industry. Medical and recreational cannabis laws, we're going to talk about a whole section on this because they're just so important now. Medical cannabis, we have many states in the country that require some kind of accommodation for a person who has a medical cannabis card. That accommodation is not going to permit them to work while they're impaired or to use marijuana in the workplace, but it might affect what you can do with a positive marijuana test. So you need to know those laws for the states in which you operate. Recreational cannabis laws, compliance is required with these laws, and it is trending now for states to say an employer cannot prohibit recreational cannabis use if the use is off the work site and off work hours. It can affect what you do with a positive drug test, and it's very state specific. So you really need to know exactly what the law says in your state regarding recreational cannabis, positive drug tests, what type of testing you can perform for cannabis. We have several states that regulate what kind of testing you can do for cannabis. I'm going to turn it over to Bill now, and he's going to talk a little bit about federal regulations and then move on to our next section.
Okay, thank you, Yvette. So in addition to state laws, as I'm sure many of you know, there are federal drug testing regulations. And the most common and the most, sort of vilified, if you will, because they're not well liked by many employers, are the U.S. Department of Transportation, the DOT drug and alcohol testing regulations. Now, if you think of drug testing in the most global sense in the United States, workplace drug testing accounts for somewhere between 40 and 45 million drug tests a year. That's our best estimate. The labs don't report these numbers, so we sort of have to gather them and then extrapolate from different sources. DOT drug testing accounts for about 6 million of that total. So it's a significant chunk of the overall drug testing market, and it's completely governed by the federal regulations, 49 CFR Part 40. So as you can see at the top, you've got the Federal Motor Carrier Safety Administration, Part 382. If you're a company with the type of drivers who fall under the FMCSA regulations, you know what these are. Second, in terms of us writing drug testing policies, we write these Federal Motor Carrier policies all the time. They're the most common, and they account for the vast majority of all the DOT mandated drug tests. If you go down a little bit on the chart to the second from the bottom, that's the Pipeline and Hazardous Materials Safety Administration, Part 199. And that's probably the second most common drug testing policy that we'll cover. We cover all of the others, FRA, FTA, FAA. We also do Coast Guard, as you see at the bottom. But Federal Motor Carrier and PHMSA are the two most common. And these laws, let me show you on this next slide here, these laws will trump state laws. So if you're an employer that has both DOT covered workers and non-DOT covered workers, the regulations from DOT only apply to those DOT covered workers. You may choose to have a DOT lookalike policy for the rest of your company employees, but it would be governed by whatever state laws apply to you. But if there's a conflict between a state law and the DOT regulations would trump those state laws as they apply to your actual covered employees. So it's very important to note that. And this comes in really handy to know because you've got states like California, for example, that has passed a new law that went into effect back on January 1st that restricts testing for marijuana with urine. And the only exception in the law is the construction industry, but it doesn't trump the DOT regulations. So if you're an employer in California with DOT covered workers, you still have to do DOT mandated drug testing for marijuana. And at this point, even though oral fluid has been approved, it's not yet effective. So the only drug testing method you can use right now under the DOT regulations is lab-based urine testing, and that has to include marijuana. And the point in using California as an example is that you find this in other states as well, where there may be something in the state drug testing law that would appear to conflict with what the DOT regulations require. But in those instances, the federal law trumps the state law for those covered workers. And so if you're ever in doubt, always understand that those federal regulations come first, and then any other employees that you have would be covered by the state laws that apply. And then look at the third bullet there. When in doubt, follow the narrowest definition provided. So laws, regulation, case law, and unemployment workers' comp laws and regulations, as the Yvette talked about, they exist in most of these states. And as you look at them, you have to be careful that you're complying with all the ones that apply to you. So for example, if you're in a state with a voluntary law, like here in Florida where I live and where Yvette lives, it only applies to companies that are participating in that voluntary program and wanting to get that 5% workers' comp premium discount. But outside of the voluntary law here in Florida, we don't have a mandatory drug testing law. So employers are actually free to drug test as they wish. They may choose to follow the same regulations that are in that voluntary law, but they don't have to. If there are any other laws, or for example, we have a medical marijuana law here in Florida, and if there were any components of that law that would affect workplace drug testing, they would have to comply with that. So, and as I mentioned before, if you're in multiple states, which I know many of you are, you must comply with the legal requirements in each of the states that you're in that apply to you. And so you want to make sure that your policy reflects the various state laws. And so we recommend customizing addendums for individual policies. You don't need, or individual states, you don't need a separate policy for each state. Most of it can be covered in sort of your base policy, but you're going to want to have customized addendums for each state where the requirements in a particular state would differ from what's in your base policy. So let's talk about the policy for a moment. So drug testing policies can include a lot of different things. This is what we recommend when we put a policy together. We start with a purpose statement, why you're drug testing. And the reason why we start with a purpose statement is because how you or why you test determines how you're going to test. And of course, you've got the state laws that apply that come into effect there as well. But it really sort of serves as a blueprint for what's going to come next in the policy when you define why you're drug testing. And the most common reason is to secure the safety and the well-being of your workplace and your workers. Every year for the last 26 years, the Current Consulting Group has conducted a survey of the drug testing industry. And we released the results of this year's survey at the NDASA conference back in May. And so we surveyed drug testing professionals on various trends. And they identify to us what their clients, employers, are telling them in terms of what their priorities are. And the number one priority when it comes to drug testing is safety. And when we ask the question, what do they perceive to be the most, the biggest benefits to drug testing, the number one answer is safety. So many employers drug test to secure the safety of their workplaces, and a fairly significant percentage, about 80%, believe that drug testing accomplishes that. And then who does it apply to? Is it job applicants and employees, or just job applicants, or maybe just employees? Post-accident reasonable suspicion is, when you're going to test your employees as opposed to pre-employment testing. Which drugs you're going to test for? Are you going to include marijuana? And then depending on the laws that apply to you, what are the cutoff levels that you're going to use? Are you going to test for alcohol as well? And very importantly, what would be prohibited behavior in the policy? Testing positive, for example, could be listed as a prohibited behavior. And what will the consequences be when somebody either refuses to submit to the test or they fail the test? They have a confirmed, verified positive drug test result. And you want to make sure that you've trained your supervisors, those who are responsible for the policy, so they understand what the expectations are. And of course, you don't want them to do things they're not qualified to do. They're not diagnosing somebody's substance abuse disorder, but they're looking at job performance and the possible link between a drop-off in job performance and the possibility of somebody being at work under the influence. Now, something I want to specify here or be very specific about is because of the situation with legal marijuana throughout the country, you want to make sure that you have a dedicated section for marijuana in the policy and that you talk about specific things that may be pertinent to marijuana. So on this slide, we talk about the things that you absolutely can include in your policy, no matter what state you're in. Even the most liberal marijuana-friendly states still allow employers to prohibit employees from bringing marijuana into the workplace, and that can include company vehicles that they operate, and it could include also remote work sites. And then you can prohibit them from consuming marijuana during the workday, including during breaks and lunch breaks. And then you can also prohibit them from being at work while under the influence of marijuana, regardless of when the use took place. I'm going to share some statistics a little bit later that talk about the trend right now of individuals to consume marijuana on their way to work. And it's astonishing how many people admit to using marijuana before they begin their work shift. So in the policy, you're going to state that you comply with all the marijuana laws that are applicable to your company, but you're also going to point out that we will not tolerate marijuana use or individuals being under the influence of marijuana. Now, it's important to emphasize that a drug test doesn't prove that somebody's impaired. That's not what we're talking about here. We're talking about prohibiting people from being at work while under the influence of marijuana, and there's a difference. So you don't want to accuse somebody of being impaired based on a drug test result, but you do want to make sure that they understand they can't use marijuana or be under the influence of marijuana while at work, regardless of what their state of impairment may or may not be. And I mentioned earlier, you may want to include in your definition that testing positive for marijuana is a prohibited conduct. And that could be for any drugs or alcohol as well. And then articulate the signs and symptoms of being under the influence, the different ways, outward manifestations of somebody being under the influence. And all of that can be included in your policy. So as you go forward to train and to share with your employees what the policy says, you want to make sure that you include specific things related to marijuana, because it's just such a demanding issue nowadays. There's just no way around that. You know, about 40 states now have some form of legal marijuana, whether it's medical or recreational marijuana. And other states, including some of those 40, but other states as well, have decriminalized possession of small amounts of marijuana. So all of those things have to be taken into account when you put your policy together. That's why we recommend having a dedicated section in the policy that touches on marijuana. At the same time, we want to emphasize that it is very possible to have a program in place, a policy that incorporates these legal marijuana laws in a way that makes it possible for the company to continue to protect itself by drug testing for marijuana, and prohibiting certain types of behavior that may be related to somebody using marijuana. We do know that with the increased legalization of marijuana, and there are lots of studies and reports that emphasize and verify this. In fact, one just came out last week, the National Survey on Drug Use and Health, which comes out every year from the federal government, that shows that marijuana use is increasing. And with that, we know that there are more impaired workers in the workplace. Part of that is through a survey, not actually a survey, but a report that comes out annually from Quest Diagnostics called the Drug Testing Index. And they include in that specific results that show trends in positive drug test results from lots of different, it's by industry, it's by state, it's by types of drugs, it's by types of drug testing, urine versus hair versus oral fluid. You can look at it all kinds of different ways, but it does show that there's been a significant increase in positive drug test results for marijuana, specifically in post-accident drug tests for marijuana. So with that, let me turn the virtual microphone back over to Yvette to take us through our next section.
Thank you, Bill. I'm going to talk to us about marijuana laws and some specific ones and some general trends and issues, but we're going to start out talking about some new laws in California and Washington because these are some big states, and we're looking to see if this is a trend that other states are going to adopt as well. So both California and Washington have new marijuana laws that took effect January of 2024, and they address drug testing that tests for non-psychoactive metabolites of cannabis and prohibit employment action based on test results for non-psychoactive metabolites. Now, California's law is more broad than Washington's. California's law applies to employees and applicants, whereas Washington's only applies to applicants and pre-employment testing. But let's take a look at some of the language in these laws. So testing for marijuana is still permitted in California. However, to discipline an employee for a positive test, there are only certain test results that can be utilized. And it's unlawful for an employer to discriminate based upon an employer-required drug screening that has found the person to have non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. Now, what does this mean? Non-psychoactive metabolites. A drug test can turn up positive for either depending on what kind of drug test it is. It is either testing for the metabolites of a drug or the actual parent drug itself. California's law prohibits action based on a drug test that is detecting the metabolites. Now, urine testing for marijuana is always going to be looking for the metabolites. And the reason is when someone ingests marijuana, the marijuana gets metabolized through their system before it gets deposited into their urine. A person's body does not deposit straight marijuana active THC into the urine. It gets metabolized through the body first. So urine tests are always going to be looking for the metabolites of cannabis. Oral fluid testing, saliva testing, is most often detecting the actual parent drug of the substance of cannabis or whatever drug it's testing for. Oral fluid testing does not require the substance to be metabolized through the body before it will show up in the oral fluid. The parent drug itself will show up in the oral fluid testing. So the vast majority of oral fluid tests are looking for that parent drug and not the metabolite. So this California law is saying you cannot discipline an employee or refuse to hire an applicant if you have only detected cannabis metabolites in their sample. Effectively, what it means is that in California, you cannot take action based on a urine marijuana test, a result from a urine sample, because that is always going to be a metabolite. Oral fluid samples, however, are not restricted the same way under this new California law because most, if not all, oral fluid tests detect the parent drug and not the metabolite. Those test results an employer can still take action on under this new law. Now, I've heard many people, New York has a very restrictive marijuana drug testing law, as well as California. And I've heard people say, oh, the California law is just like the New York law. And that is actually really not accurate. So we have this chart just to break it down a little bit. The first horizontal bar we have says, can you test for marijuana? In California, yes, you can still test for marijuana. Actually, in California, you can still test for marijuana using urine or oral fluid or hair. It's just going to affect what you can do with a positive result. So California, yes, you can still test for marijuana. In New York, you are prohibited from even testing for marijuana in most circumstances. There are some exceptions, but overall, the New York law is restricting any testing for marijuana, period, it's not just addressing what you do with a positive result. So our second bar, can you discipline for marijuana use? In California, you can discipline for a positive marijuana test if it is a test that is not detecting metabolites, it's detecting the parent drug. So the California law, can you discipline for marijuana use? Maybe, depending on what kind of testing you're conducting. In New York, again, we come back to you can only be testing for marijuana in very narrow circumstances. So if you fit into that exception and you're allowed to test for marijuana, then you can discipline if required by law. Our third bar, can you prohibit off-duty marijuana use? Both in California and in New York, an employer cannot prohibit an employee from using marijuana off-duty and off the work site. That is not allowed in California or in New York, but conducting testing is different in the two states. Now, Washington's law only applies to pre-employment testing. And as well, Washington's law has a very long list of positions that are exempted from this new law, including safety sensitive positions. So Washington's law is going to apply to far, far fewer drug tests than California's. And I should mention for California as well, the building and construction trade is exempted from this new California law. So if you're working in building and constructing, then that California law does not apply to you. That's one of very few exceptions in California. Washington has a much longer list of exceptions. And as well, like I said, Washington's law does not apply to the testing of employees. Now, the importance of both laws. This is very interesting as we see New York's law, California's law, Washington's law. We are starting to see legislatures regulate what kind of drug tests you perform. Before, it has been you can drug test, but what can you do with a result? We are getting more and more into states regulating how you drug test for marijuana. Washington and California are really effectively giving a preference to oral fluid testing. And effectively, again, the reason for that is because, as I said, with urine testing, the marijuana needs to be ingested, metabolized through the body before it becomes deposited in the urine. This process takes more time. And so you are not getting a positive on a urine test as quickly for marijuana as you are getting from an oral fluid test. Because in an oral fluid test, the marijuana, the cannabis, does not need to be metabolized through the body before it's deposited in the oral fluid. So you get a positive on marijuana a lot closer to the time that the marijuana is ingested as compared to a urine test. And we're going to talk about that more going forward. But it's really important to understand that oral fluid testing detects the active THC parent drug rather than the metabolite. So what do you do with marijuana testing? Number one, the most important thing when you're looking at your policies is to know what the laws are in the states in which you operate. That is just absolutely essential to be educated on what the laws are in those states. And number two, you've got to go back to your policy and make sure that it's up to date. Don't create a policy and stick it in a drawer for 10 years and not revisit it. These laws are changing so rapidly when it comes to marijuana and testing and discipline. Your policy needs to be up to date and as comprehensive as possible. Number three, if possible, use a testing method that's endorsed by SAMHSA. As of now, that is oral fluid testing and urine testing. That puts you on the most sure legal footing for defending your results if it came down to that, legal defensibility. And if you're doing lab-based testing, use a SAMHSA certified lab, or if you're doing rapid testing, use an FDA cleared device. Again, that's going to give you the most legal defensibility because these are methods that are being endorsed by the federal government. And number five, don't ignore legal marijuana laws. We are just so far past the point where we can ignore those laws. Your policy has got to address them specifically, and you've got to know what the laws are to make sure you're in compliance. So I'm going to turn it back over to Bill to talk about the consequences of dropping marijuana.
All right, thank you, Yvette. Now, on these next two slides, I'm going to share some statistics with you, and you're going to be feverishly trying to take notes. You're going to have the recording of this webinar to go back and look at it. So don't worry if you don't get all these numbers written down, but they're very compelling. They're very interesting numbers. So for example, positive drug tests for marijuana between 2021 and 2022 increased 10.3%, according to the Quest Drug Testing Index. In states where they've legalized recreational marijuana, it increased 11.8%, and in states with medical marijuana, it increased 8.3%. You may be wondering, did it increase in the states that haven't legalized some form of marijuana? And the answer is yes, but it was a much smaller percentage, but it did increase throughout the country. Now, very interesting, that third bullet, between 2012 and 2022, during that 10-year period, post-accident marijuana positives, as I referred to earlier, increased by over 200%. So we're seeing a lot more individuals in the workplace, including job applicants, testing positive for marijuana. And we're seeing a lot more positive drug tests for marijuana after accidents. What's interesting, I don't have the statistics on the slide, but there was a report that came out from a fairly large drug testing provider in our industry. And they looked at they compared the positivity rate of companies that have dropped pre-employment testing and their positivity rate for post-accident. And among companies that have discontinued pre-employment testing, the post-accident positivity rate, not necessarily just for marijuana, but for all drugs, was significantly higher. If you drop pre-employment testing, you're going to have more drug-related accidents, and the post-accident positivity results sort of bear that out. So let me get to the next slide. I mentioned that we do a survey of the drug testing industry every year. In this year's survey, 59% of drug testing professionals, these are drug testing providers, laboratory people, TPAs, MROs, etc. They said, 59% said they believe the decision to discontinue testing for marijuana encourages employees to consume marijuana before work. So if you're concerned about individuals showing up for work under the influence of marijuana, you want to continue testing for marijuana. If you drop marijuana from your drug testing panel, it's like a green light to those who want to smoke marijuana before they even start their work shift. In fact, there was a study earlier in the year, a survey of 500 marijuana users who were employed. 31% admitted to using marijuana well on their way to work, and 48% said they used marijuana well on the job, including during breaks during the day, in lunch breaks as well. And then there was a different study from the American Addiction Centers where they found that 22% of individuals who admit to being current drug users say they use during the workday. And I know some of you probably have at-home or remote workers. And in that same American Addiction Center study, 40% of the people who work from home full-time say that they've gotten high before or during their work hours. So drug testing has proven to be a powerful deterrent to drug use. It doesn't necessarily mean people aren't going to use drugs on the weekend and they're not going to smoke pot on their own time. And in many states where marijuana has been legalized, they have certain protections against discrimination when they use marijuana on their own time away from the workplace, as Yvette was saying. But it doesn't give them the right to use marijuana in a way that causes them to be at work while under its influence, especially if they're driving a delivery van or operating a forklift or some other safety-sensitive occupation. You don't want them smoking a couple of joints on the way to work and then showing up with the drugs in their system. And as Yvette talked about, oral fluid testing detects the parent drug. So if somebody used marijuana 15 minutes ago, it's going to most likely show up in an oral fluid test. Whereas with urine, you've got that 6 to 7 hour lag time from usage to when somebody would test positive before the body metabolizes the drug and it shows up as a metabolite in somebody's urine. That's important to know if you're in one of these states that has legalized marijuana and you're concerned about safety-sensitive occupations. So, and I've already talked about these. These are the things, the pros and cons of testing for marijuana. I want to emphasize on the right side under cons that drug testing doesn't measure impairment. It doesn't prove legally or scientifically that somebody's impaired. But your policy can be worded in such a way that it prohibits individuals from having marijuana in their system during the workday. And an oral fluid test is going to reveal very recent drug use, which is probably more sort of drug testing / marijuana friendly in states that have legalized marijuana. Sort of the hot button issues when it comes to marijuana, and there was a study that came out of the University of Sydney that showed that the impairment window, or the window of impairment, the period in time in which somebody's going to be impaired by marijuana, is usually 3 to 10 hours. It depends on a lot of things. And you see under the first bullet, there's one that says varies depending on the THC level of the marijuana that was used, the frequency of the use of the marijuana, how the cannabis is consumed, smoking versus edibles, and what tasks you're asking them to perform. Are they driving a delivery van versus, greeting customers as they come into your store? Now, I will say that here in Florida, it's very common for somebody to come to your door and offer to trim the palm trees in your yard. We have a lot of palm trees here. And somebody came to my door, said, yeah, and I can do all of it for X number of dollars. It was a good price. Said, I'll be back tomorrow with the crew and we'll do that. When he came back the next day in the morning, first thing in the morning, I opened the door and he reeked of marijuana. I mean, it was just so strong. And I said, I can't have you and your guys climbing up on tall ladders into the top of these trees when you've all been smoking marijuana on the way to work. Well, I've got the right to refuse to hire somebody to do that. In the workplace with employees, you also have the right to prohibit them from coming to work under the influence of marijuana, and you state that in your policy. So as it says on that last bullet, ensure your testing method covers that entire window of impairment of 3 to 10 hours. You don't want a testing method that has a very short 1 or 2 hour window of detection period, but you also want one that at least covers that 3 to 10 hour window, if not longer. But in states where marijuana has been legalized, you're going to want to have that kind of tighter window of detection so it doesn't look like you're trying to discriminate against marijuana users in your workplace. This is just a sad example. I'll go through it quickly, but this was from 2021 in Albuquerque, New Mexico. 4 people had signed up and paid for a hot air balloon ride, and unfortunately the pilot was under the influence of cocaine and marijuana, and he crashed into a power line. It caused the basket to detach from the envelope and it plummeted to the ground, and all 5 people, the 4 customers and the pilot, were killed. And the NTSB came and did a full investigation and concluded, quote, contributing to the accident was the pilot's use of impairing illicit drugs. Some impairing effects of THC would likely have been present that would have affected the pilot's ability to successfully operate the balloon. So a very sad situation. Unfortunately, this is not uncommon. Workplace accidents related to drugs don't always involve a fatality, fortunately, but there are a lot more accidents in the workplace today because of the legalization of marijuana, and all the things that come with that are on the screen right here. But you want to just make sure you have a policy in place that protects your company in the event that you have workers who choose to be at work while under the influence or use marijuana while on the job. Okay, back to that.
Thank you, Bill. We're going to talk a little bit now about oral fluid testing versus urine testing and hair testing, just to help you make the right choice for your workplace. There are many testing methods available today. We have lab-based versus instant testing. So both urine and oral fluid testing can be processed through a lab or can be done on site in an instant test. And there are pros and cons to having instant versus oral fluid. We also have hair testing. Now that can't be an instant test, but that's another consideration for employers to think about when deciding what testing method to use. Oh, sorry. Here we go. Federally endorsed drug testing method. What do we mean by federally endorsed? It means the federal government, in making their decisions as to what drug testing methods can be used for federal government programs, they have chosen these methods. And as we all know, the federal government does not make quick decisions. The federal government takes a long time in doing studies and hearings and comment periods before issuing regulations. So the fact that the federal government permits and legalizes these drug testing methods means these drug testing methods have gone through extensive study and comment and research before being endorsed. We have lab-based urine testing. That is what has been around forever, right? We also, as of May 2023, have lab-based oral fluid testing. So oral fluid testing, while at one point in time it was the new thing, now it's endorsed by the federal government. It is right up there equally with urine testing as being that gold standard for drug testing. Hair testing is something that is being researched, commented on, that sort of thing by the federal government. It's not approved yet. It's something that maybe is coming soon. So I'm not going to go through all of the information on this chart, but I'm going to walk you through some of it, comparing the drug testing methods. What I think is really important to take a look at is the window of detection and recent use detection. I talked about how lab-based or rapid results are available through urine or oral fluid. Let's look at the window of detection. Now, when I say the window of detection, it means how long is this drug testing method potentially going to come up with a positive test after use? Urine testing is the one where what most people know is you can test positive in urine for a very long time after use. Urine testing has a longer window of detection than does oral fluid testing. Hair testing has the longest window of detection, right? I mean, you are going to have the metabolites of a drug in your hair until you cut that hair and discard it, right? So hair testing, a lab is going to detect it all the way up to like 90 days out. Urine testing can be like 3 to 4 days. You know, there's some debate on that, but with the appropriate cutoff levels, usually urine is going to detect a substance for 3 to 4 days after use. Oral fluid testing in a lab can be about 24 hours, can be up to 24 hours for marijuana, 24 to 48 hours for other drugs. For instant testing, for instant on-site testing, we label that POCT, it's point of care testing. That can be up to 12 hours for marijuana. So oral fluid has a much shorter window of detection. For some employers, and in the past, that has been a downside in that they want to know someone's historical use. Some employers want to know whether someone used marijuana last week. But with the current state of marijuana laws, in many, many states, you need to know whether someone is impaired on the job or whether someone has used marijuana just before coming to work, rather than knowing their historical use of marijuana. So that can be a plus or a minus for oral fluid. And recent use detection, like I mentioned when I was talking about metabolites versus detecting the parent drug, oral fluid is going to detect substances in a person's body much, much more quickly than urine, because it does not need to wait for the substance to be metabolized through the body. Oral fluid testing is going to detect those substances within minutes after usage, whereas with urine, there's a lag time. With hair, there's a very long lag time, because not only does the substance need to metabolize through the body, then the hair has to grow from within the root until it's, further out where you're going to actually extract that from the hair. So hair testing is not at all testing for recent use. Hair testing is testing for historical use. Oral fluid testing is only testing for recent use. Oral fluid testing is not going to get you results from last week, from several days ago. Oral fluid is only testing for recent use. And then urine is kind of in between. There's the lag time, but not as much lag as hair testing. And it's not going to detect usage as long as hair testing, but it is longer than oral fluid testing. Urine testing is legal everywhere. Oral fluid testing is legal almost everywhere. There are very few exceptions, that very few states that don't permit oral fluid testing. Now, blood testing, the reason I'm not mentioning this very much is because it's just really not permitted for workplace drug testing, as we can all imagine why. So let's look at pros and cons of urine testing, and some of these I've touched on. It's what's been around the longest, right? It's what most people are familiar with. It's always been the gold standard. You have a lot of flexibility. What kind of panel do you want? It's permitted for DOT and other federally regulated employers. It's legal in every state. It's been through legal challenges. You know, it's the historical gold standard. The cons are the collection. One of the cons is the collection method, right? There's not a lot of privacy. There's an ick factor in the collection. Employees don't like giving a urine sample. It is uncomfortable and feels invasive. You have issues with drug testing cheating. You know, do you give someone privacy to do their urine deposit and then face the chance that they are doing something to try and cheat the test? If you are trying to observe someone to make sure they're not cheating, what do you do with gender issues? You know, some people are going to claim a shy bladder or actually do have a shy bladder and not be able to give a urine sample. And then the window of detection, like we talked about, the lag time between the time they used and the time it's going to show up in their urine test. We are running short on time, so I'm going to quickly go through oral fluid testing. If I can get my slide to advance. There we go. Lab-based, the collection for oral fluid testing is so much easier than urine testing. You can collect anywhere, anytime. You do not need to have a collection site. You do not need to send employees to a collection site. If you have workers who work in remote locations, either remote meaning at home or remote meaning they're far away from civilization or from a big city or from a collection site, you can collect those samples, those oral fluid samples right there on site, and then send them to the lab. And you don't have to send all of those employees out to a collection site. It's so much easier. And you can do it in the middle of the night. You can do it at, 6 a.m. Depending on your employees' schedules, you can collect anytime and send that out. You are face to face with the person as they do either like a mouth swab or a spit, depending on, what test you're using for the oral fluid. You're face to face. You're watching them. It's almost impossible for them to cheat because you're watching them do the collection. The recent use detection we talked about, and now it's endorsed by the federal government. So we are like out of time. And I've talked about some of these issues. I'm going to send it over to Bill if he wants to talk about quickly on-site testing, rapid testing, before we close up here.
Yeah, I think we'll just leave that for you to look at when you review the slides, because we're going to send you the link to the recording. And then if you have any specific questions about rapid testing, we're happy to answer those for you, whether it's rapid urine or rapid oral fluid testing. And we want to remind you as well that if you need any help with any drug testing policy issues, that's a service we provide at a discounted rate for Scott Insurance customers. And Brett, I think we're probably out of time. Do we have time for one question?
It's actually the top of the hour, Bill. So we will have to go ahead and answer all the questions offline. But thank you, Bill, and thank you, Yvette, for a great presentation. On behalf of the Current Consulting Group and Scott Insurance, we hope you found today's presentation informative and helpful. Once again, I want to thank Bill and Yvette for speaking on this topic and sharing their expertise. I also want to thank Scott Insurance for sponsoring today's webinar. If you submitted a question that we didn't answer here today, we will answer you offline, and we will also send you a follow-up email on how to access the recorded version of today's presentation. In addition, we will also send you continuing education information for those who qualify to receive 1 credit for attending today's presentation in its entirety. Thank you for your attendance today, and this concludes today's webinar. Have a wonderful day.